Good morning, everyone. Welcome to another edition of HR Fridays. My name is Clinton Drell, Managing Director of On Demand HR. Today, we are going to cover unfair dismissal. And we're going to talk through the process of an unfair dismissal claim and how you would deal with that in the Fair Work Commission. Every Friday at 10 a.m, we're going to present on a different HR and IR topic, so please let us know any future topics of interest. If you're watching live, please feel free to ask any questions. The whole purpose of HR Fridays is to try and provide businesses, our professional advisors and other associate members, which is advice, which is reality, trying to stop the noise and the scare tactics of other consultants that you might hear out there in the marketplace. We've been in the Fair Work Commission many times. We've done many workplace investigations and we've dealt with the Fair Work Ombudsman many times. And we can provide real perspective on these issues, not just theory. So www.ondemandhr.com.au. So let's get stuck into unfair dismissal today. So I guess let's just sort of start with some basic principles of how an unfair dismissal application would come about. So first of all, the employee must submit what is known as a Form F2 application for unfair dismissal. So they must do this within 21 days of them being dismissed from their employment. The application cost currently is around $74.50. So it's a very, very low barrier to entry in terms of making that claim in the commission. The employee must be earns less than $153,600 as of the 1st of July 2020. There are some exceptions to that rule, but generally speaking, you must be under that amount to make an application. The system is designed so that people can be self-represented in the process. So that is something to be aware of. It's a no costs jurisdiction in the Fair Work Commission. So that means that win, lose or draw, typically you will not have your costs covered by the other parties. That's very important to understand when you're going into these claims, because even as an employer, if you think that you may be in the right on various things, there's still going to be costs associated with you having to go to hearing to prove that you are right, in fact. So that is a consideration that always must be front of mind. As far as the early steps for the employer, so the employer typically, when the application's filed with the Fair Work Commission, typically the employer will then receive it a few days after. It'll be sent by the Commission to the employer for them to provide a employer's response to. So that is the Form F3, employer's response. And typically the obligation is to provide that within 7 days. Normally, the Fair Work Commission would then schedule a teleconference for conciliation within 2 to 3 weeks is what we find most of the time, sometimes a little bit more, sometimes a little bit less. So that's what you can expect as far as the Commission's early processes are concerned. So we then go on to, I guess, the telephone conciliation and what is involved with that. So first of all, the Fair Work Commission will organise a specialised conciliator to the matter to conduct the conciliation. So that the first thing to understand is that you won't necessarily have a commission member facilitating conciliation. In fact, that's quite rare. You'll more likely have what they call a staff conciliator. So that is someone who's a specialised conciliator who's got a very good understanding of the law, an understanding of the key principles around unfair dismissal and so on. In a conciliation conference, it normally runs something like this. So each side will have an opportunity to present their case uninterrupted for about 10 to 15 minutes. And bear in mind, the conciliator doesn't make any decisions. They purely listen to both sides of the argument for the purposes of negotiation. So the applicant, so the individual who's made the application goes first, and then the respondent, the employer, goes second. So that can either be done directly by the applicant or by the representative, and the same with the respondent. It can be done by their representative as well. On Demand HR, we've been a paid agent over 150 times in unfair dismissal matters since 2010. Paid agents and advocates are very, very common in these particular matters. Lawyers also play in unfair dismissals, but it's important to note that in these situations, it can be a very good idea to use a consultant or an agent such as us to run one of these matters, particularly when those people are specialised in those types of services. So, so that's ultimately what happens at the start of the conciliation. The conciliator may make some early comments about the submissions made by the parties at the start of the conciliation. the parties may then enter into some negotiations to resolve the matter, and the conciliator may break off into what we call private conferences. So they may break off and speak to the applicant first, maybe understand what sort of money or outcome they're wanting to resolve the matter. They may then speak to the respondent or the employer to see, well, what are they prepared to do to resolve the matter? Are they prepared to put anything monetary on the table? I mean, most of the time, it's a monetary settlement that resolves these things. There are sometimes other situations that may come into play, such as, look, sometimes there might be no monetary offer, but simply a reference or a statement of service or something like that. Sometimes there might be an agreement to reinstate a person into their position. That is extremely rare, but it can happen. In terms of hearings, reinstatement happens around about, I think it's about 3% of cases. So it's pretty rare that reinstatement is awarded, typically and more likely when unions are involved on the applicant side. In terms of the negotiations, so the conciliator, as I said, doesn't make a ruling. They purely put strengths and weaknesses to each side as to what they can expect in the process going forward. And yeah, obviously, if they don't resolve at conciliation, well, then the matter goes to a hearing at the Fair Work Commission. So following the conciliation, you would then get directions for evidence. So typically what happens in those directions is that the applicant would be given a couple of weeks or 2 to 3 weeks to file their evidence and submissions. So submissions is sort of an outline of your case, formal outline of your case. Bear in mind that what you say in conciliation is not necessarily binding. That is on a without prejudice basis. So you can sort of say things in conciliation that you don't necessarily need to be solid or proven. But when you start getting to submission stage, you need to say things which are much more solid in your case. Otherwise, those submissions obviously can be criticised during the unfair dismissal hearing process. So you would file submissions and evidence. When I mean evidence, you're talking statements and attachments to those statements typically is what you would see. So typically 2 to 3 weeks for the applicant, then 2 to 3 weeks for the respondent to respond to those things, and then the applicant typically gets another 2 to 3 weeks after that to provide anything final that they wish to put forward. Then we're off to a hearing. So maybe after, let's say, 3, 6, 9 weeks, plus a bit of extra time, maybe after 12 weeks, we're off to a hearing at the Fair Work Commission. And then essentially that's when we kind of have a courtroom style hearing, if you like, more informal than a courtroom. There is 2 types of, I guess you could say, formal decision processes. It's either a hearing or a conference. A hearing is more common. A conference is kind of less formal, where the parties might seek to do a conference when one or both of the parties is unrepresented. But typically, if both parties are represented, you're off to a hearing. In a hearing, basically, again, businesses can appoint an advocate like us, who's not required to be a lawyer. We've run many cases all the way to hearing. You'll see my name in case law, various different matters we've run in the past. And ultimately, there is an opportunity during the formal process even to reach an agreed outcome. The conciliator may very well, or should I say the commissioner who runs the hearing, may roll up their sleeves and say, look, I still think we can resolve this. There might be a discussion prior to the formal hearing on the day about still solving the matter, and that can result in a resolution. In terms of if that doesn't happen, well, then what will happen is that the applicant will typically put forward witnesses. The respondent will put forward witnesses. Those witnesses will provide evidence. They'll be cross-examined on their statements, and then they'll be re-examined by their representatives about the evidence they've given. The commissioner might hear this over 1 day, 2 days, or 3 days, depending upon how many witnesses are involved, how complex the matter might be. And then after all of the evidence is heard, all the submissions are provided, the commissioner will then make a decision. But that decision typically won't come out for another, it could be 4 to 5 weeks or 6 weeks after the actual hearing has taken place. So you won't get a decision on the day, like you might see in Law and Order and TV shows like that. But you will get a decision in the coming weeks. So I think some final considerations on unfair dismissal are as follows. So the Commission can award up to 26 weeks compensation if it determines that an unfair dismissal or a dismissal is unfair. Section 392 of the Act talks about the factors that the Commission considers when awarding compensation if it finds a dismissal to be unfair. So just so I can be clear as well, an unfair dismissal is a dismissal that is harsh, unjust, or unreasonable. those concepts are obviously very loose and defined in very many different cases over the years that have defined these things or provided clarity around these things in certain cases. So Section 392 talks about how compensation is considered. It factors in things like, has the employee found other work since being dismissed? Have they been paid any other money since being dismissed? And those factors can be discounted against what the compensatory award might be. In terms of Section 387 of the Act, that's another very important part of the Act because it talks about the criteria for how the Commission will consider an unfair dismissal, what it considers when determining whether a dismissal is harsh, unjust, or unreasonable. So that's a really good section to be across as well. Again, at all stages during the process, parties can negotiate. Again, there's a great opportunity to appoint an agent such as us, particularly when we do the lead up into the termination. If we've given you advice around having a good, procedurally robust, unfair dismissal process, or should I say dismissal process, then you should be in a great position to defend an unfair dismissal later on, or there should be, at the very least, a position of manageable risk. So that's important to note. Unfair dismissal is a highly specialised area. There's a number of generalist lawyers that don't have the experience in this area. So that's important to note as well, that just because you've appointed a lawyer doesn't mean that necessarily that person is going to be great, very effective at these particular types of matters. We see a lot of, I guess you could say, generalist practitioners that we come up against the Fair Work Commission, and I would say that we have an advantage in dealing with those matters. Others might laugh at that and scoff at that, but that is, in my observation, the reality of the situation. We deal with so many of these that we've become very specialised in this area. But some of the employment lawyers are obviously very, very good and very difficult opponents at times. But yeah, certainly one part of our service that's a little bit unique is that we can give advice leading up to the termination to set it up for the response afterwards. And there's a great, nice continuity there of advice given prior and advice given after and representation after. So that's pretty much unfair dismissal in a nutshell, the process, what to think about, and how you might consider some of these matters. So look, really appreciate your time once again on HR Fridays. Hope you've got something out of today's session. If you've got an unfair dismissal matter that you have or a dismissal that you are considering, please get in touch with us at On Demand HR, www.ondemandhr.com.au. Once again, it's Clint Indrell, Managing Director at On Demand HR. Have a fantastic weekend, and we look forward to talking to you again soon. Bye for now.